There have been a number of new seats opening across the globe in recent years. Does this regionalisation necessarily mean globalisation for arbitration?
Well, thank you, Andrew, for the introduction. I'm very pleased to be here to speak on this panel and at this conference. What I wanted to do was, we've heard some very excellent explanations with John Beechey's lecture last night and also on our first panel this morning of some of the key legal infrastructure that you need for a seat to thrive in the international arbitration sphere. What I particularly wanted to focus on was the globalisation of international arbitration. And what I want to suggest to you is that globalisation has led to standardisation of practice and procedure, and that in turn has led to regionalisation. So in order to try to make my argument good, what I need to do is go back a little way in time. So I'm going to go back to 2010, and I'm going to quote from one of the most oft-quote surveys in international arbitration, which may sort of lack for broad statistics, but is often quoted, so I'm in good company. The Queen Mary survey, White and Case survey from 2010, which is now 7 years old, and if you went back to that survey from 2010, what you would see is that London was the most preferred seat for international arbitration, followed by Geneva and Paris, but a reasonable distance behind, I must say, then Tokyo and Singapore, and finally New York. New York being at the back of the pack slightly surprised me, but that's where we were in 2010. And since 2010, we've seen, I think, a growing standardisation of international arbitration procedure and agreement about what constitutes good practice. And I wanted to give you just a few examples of that. So one example is the modern version of the IBA rules on taking evidence, which is actually very widely adopted in international arbitration procedures, dealing with document requests and how witness evidence should be given and so forth. And that was adopted in 2010, and that, as I say, is now widely used. It's actually a relatively short space of time. The IBA's guidelines on conflicts of interest, again, they're very widely used. Most people will turn to them if you're going to be appointed as an arbitrator and determine whether you need to make a disclosure. First in existence in 2004 and updated in 2014, again widely used. The other evidence that we have for practice becoming more standardised is the institutional rules, which have become more homogenous. Innovations, you can see, are widely and quickly adopted. So if one institution makes an innovation in recent years, they're quickly adopted by another institution. Probably one of the best examples of that is the emergency arbitrator provisions, other provisions like consolidation and joinder, and most of them are available in the leading institutional rules, the HKC, SIAC, LCIA and ICC. But also there's broad-ranging concession on some of the less exciting procedural issues. So, for example, conferring broad discretion on the tribunal for costs. There are a slightly different emphasis in the procedural rules, but broadly they give tribunals similar discretion. So what has been the effect of this emerging global consensus? Well, I started off talking about the Queen Mary survey in 2010, but if you were to fast forward 5 years to the next survey, which was 2015, you'll see that although London and Paris are the clear frontrunners, according to that survey, with Geneva and New York, Stockholm still recognised, what is striking is there's clear recognition for Hong Kong and Singapore as leading centres of arbitration. And you'll remember that Hong Kong wasn't there at all in the 2010 survey. So what do they have in common? Well, you heard a little bit about this morning. They all have a very strong modern arbitration legal infrastructure. They're signed up to the New York Convention. They have modern arbitration law, and in fact have been quicker than other jurisdictions to update their law where they perceive that there's a problem, such as looking at third-party funding and so forth. They have a very supportive judiciary, and they are now have leading world-class arbitral institutions in the form of HKC, SIAC, and backed by some of the leading arbitration practitioners in the world. Now, it could be the reason that for the growth of arbitration in Asia, if you were to look at that as an example, is that some of the work is coming from litigation. That makes the most obvious sense in some ways. There was always disputes in Asia, and many of the disputes which were going to court in Asia are now going to arbitration. But in a lesser known survey, but still equally important, at least according to me, the IBA Ob40 group, which is a subcommittee of the IBA group and on which I co-chair, carried out a survey of practitioners in 2015. And one of the most interesting things about that survey, at least from my perspective, was that practitioners in North America were saying, we noticed that disputes used to come here to arbitration, but in fact they're now going to Hong Kong and Singapore. So this to me suggests that actually it's not as simple as all the work coming away from the courts, but in fact there is some shift in, once you get the development of an arbitral centre in a region, then the international work which may have gone elsewhere will flow to that arbitration centre. And once we've had this establishment of the room, so what we've seen with Hong Kong and Singapore is that they adopted modern arbitration infrastructure, and that gives them instant credibility because they can say we are part of something which is recognised and it's standard, and you've got nothing to fear by referring your disputes to this particular jurisdiction. And what I think is particularly interesting is that in very recent years we've seen many different jurisdictions following suit. So already established, but developing further, the Kuala Lumpur Regional Centre for Arbitration last revised its rules in 2013 to adopt the well-respected and recognised UNCITRAL arbitration rules. In 2011, LCIA MIAC was established in Mauritius, competing for arbitrations from India and Africa. They also had a legislative reform programme, and they also have the Privy Council as their final court of appeal. They have recognised institutional rules because they've essentially adopted the LCIA rules. More recently, in India, there has been a complete reworking of their legislation in 2015, and in 2016, in Mumbai, the Mumbai Centre for International Arbitration was established. And I can tell you from personal experience, because I've been to Mumbai and spoken at one of their sessions for young practitioners in the region, that there is tremendous excitement about this development. There were some 150 practitioners turned up to a seminar on a Saturday there. Again, their institutional rules are based on amalgamation of best practice, and in fact I think India is quite interesting in the changes that they made to legislation. So they almost marketed through legislation. One of the things that India is best known for, and the court's best known for, is delay. So they incorporated into their arbitration legislation that arbitration disputes must be resolved within 12 months unless you agree an extension to 18 months. What I understand from practitioners there is whether or if you don't manage to get your arbitration done within that period of time, you need to go back to court and get the court to order an extension. And we are now starting to get to that time period where the initial arbitrations that started off will now need to go back to court. So we'll have to see how the Indian courts deal with it. But in order to really demonstrate themselves as a credible institution there, that obviously will have to be dealt with promptly. Russia, Timur is going to speak about, but they've recently changed their arbitration. And the Caribbean, we've heard a lot about BVI, who's done tremendous work in this respect. And I think Anthony will speak more about it. Mm-hmm. So what I would say is, what you can see is that where Hong Kong and Singapore first went in adopting some of the fundamental, well-respected and best-known practices in international arbitration legal infrastructure, others are following suit. And I would suggest that the result of this is that we will end up with a regionalisation of international arbitration. Now, one of the things that flashes to your mind when you start to talk about regionalisation is, particularly in this world, is perhaps some of the backlash that we've heard against globalisation, to draw a comparison with politics, some of the recent Trump administration and the British vote to leave the European Union. But I think actually this is something potentially very different. What we're seeing is a regionalisation, and I think Arabella used the word network earlier, and I like the use of the word network. I think that's really important. What hopefully we'll see with this regionalisation is that you will then start to have different foundations, or foundations for international arbitration in a range of different jurisdictions, and we'll end up with a a network of international arbitration where arbitration centres are supporting each other in the growth of international arbitration as a dispute resolution process worldwide, rather than competing to the extent that they will ultimately defeat each other. So those are my thoughts on regionalisation as a result of standardisation.
Thank you, Angeline. That was excellent. And so the clear message then is collegiate and regional and international. George? Gorgeous George? What do you think?
It's the first time when someone's introduced me on a panel. I'm genuinely grateful, even if you're completely dishonest. Thank you, Andrew. Ladies and gentlemen, as an antidote to Angeline's optimistic, positive analysis of the state of international arbitration, it falls to me to approach the topic from a different perspective, a rather more negative perspective. I am the Darth Vader to Angeline's Princess Leia. Therefore, perhaps contrary to my natural instincts, I'm going to consider relatively briefly the extent to which arbitration continues to be focused on national laws, the importance of the seat of arbitration, the extent to which it's not possible to describe arbitration as a transnational means of resolving disputes, and focus perhaps on the extent to which it's not applied consistently around the world. And it seems to me there are four potential subtopics to address briefly. First of all, the difficulty that parties have in resolving certain multi-party or complex disputes via arbitration. Secondly, the extent to which the primacy of the law of the seat is approached on an inconsistent basis. Thirdly, we've heard a great deal about this already from John Beechey's fantastic address last night about the backlash against international dispute resolution certainly in the investment context. And then briefly, diversity as well. I'm going to speak for about a minute and a half or so on each of those subheadings, and then hopefully there'll be scope for some debate, time permitting, later on, or even interjection from the floor. So do interrupt me if you disagree vehemently with anything I say. Well, the first of those, difficulties in resolving certain disputes before individual tribunals alone. It seems to me that until arbitration can genuinely say that it's capable of resolving all forms of disputes before a single tribunal in a single context, it's not possible to describe arbitration as truly international. Now, there's obviously scope for debate about this, but take, for example, the high-profile UKOS dispute. One has the arbitration, the Energy Charter Treaty arbitration before an esteemed panel of arbitrators. One also has litigation before the Russian courts, English courts, the courts in the Netherlands, courts in Stockholm, and hearings before the European Court of Human Rights as well. In short, one can't resolve a dispute such as that via arbitration alone. But what about the different categories of disputes? Well, particularly in the context of certain civil fraud claims, asset tracing disputes, has arbitration truly managed to develop systems that can deal with those disputes? I'm sure that there'll be individuals in the audience who will be able to shoot that argument down pretty quickly, but it bears some discussion. Part of that potentially is the difficulty that one has in getting readily enforceable injunctive or interim relief from arbitral institutions. And I was interested in that regard to speak to one of the heads of the major European institution last week, who was bemoaning the slow take-up of emergency arbitrator provisions in the particular institutional rules. And it seems to me to point to the fact that parties have not yet embraced arbitration as a truly international means of resolving all disputes. Secondly, what about the role of the law of the seat? Well, one needs to give thought to the extent to which someone like Professor Emmanuel Gaillard might argue, arbitration is truly transnational. Is it this autonomous body of law that rides above national law, or is it grounded in the law of the seat? As for example, Lord Mance advocated in the Mance-Gaillard duel in Paris a year or so ago. Well, consider for example the different approach to awards which have been set aside in the country of the seat of the arbitration. You have on the one hand practitioners in certain jurisdictions who would regard such awards as ceasing to exist. You have some practitioners who would regard this just as a matter for the country in which the award is going to be enforced. In France, they would look towards their French civil procedure and say, well, that's all that matters. And then this brings us to cases such as Dalla, where you end up with the UK or English Supreme Court reaching one conclusion on enforcement, and the French Cour de Cassation reaching the polar opposite conclusion. So until arbitration is able to reach a stage where one has consistency of decisions, particularly in major centres such as that, I would suggest that we can't describe it as a truly international form of dispute resolution. The third of the four subtopics was backlash against certain treaties. Now, those of you who were here last night heard about this in some detail, so I'm not going to go through it at any great length. But contrary to Angeline's view, it does seem to me that the Brexit movement, the protectionist policies we see in particularly North America and elsewhere, are reflective of a move away from international dispute resolution. There's definitely a sense that parties are concerned, or rather the public is concerned about this. And I think that, again, until we can address those concerns, issues such as transparency, all the points that John Beechey addressed last night, we are not able to describe our arbitral community as a truly international one. Finally, diversity. Now, I'm conscious that this is a topic for another panel, but it's right to recognise, of course, that despite all the tremendous efforts of groups such as Arbitral Women, the Pledge, that there's still a great deal to do. Until we have a group of arbitrators that comes from every country, properly representing the global population, I don't think we're in a position to pat ourselves on the back and say that we are part of a community which is truly international. So, ladies and gentlemen, those are my four topics and food for thought, and hand over to Andrew.
Well, George, that was incredibly brave of you to come and give arbitration a working over an arbitration conference. It's clear we are on a journey, and there's perhaps no other state that is on such a journey as Russia and their new adoption of arbitration guidelines over there. And so, Timur, I'm going to hand over to you. We've heard some of the limitations of arbitration from George, but what are your recent experiences in Russia?
Well, thank you, Andrew. I would like actually to cover three issues that affect international arbitration in Russia, but also, I would say, international arbitration globally in relation to Russia-related disputes. So, first one is the new law which was adopted, entered into force recently actually, which provides that for an arbitral institution to be considered an arbitral institution, it needs to have an authorization from the Russian government to be able to administer arbitration proceedings. So this relates not only to arbitration institutions which are located, registered in Russia, but it also relates to arbitral institutions which are located outside of the Russian Federation. There are different requirements with respect to which documents need to be submitted and what kind of requirements they need to comply with. For Russian institutions, it's quite a detailed list of requirements. They need to have a special list of arbitrators. 1/3 need to, have PhD in law. Half of them needs to have.
Anthony will be fine. The rest of us.
Oh goodness! Half of them need to have experience of more than 10 years in resolving disputes. But that's for Russian arbitration institutions. For foreign arbitration institutions, they need to be, as the law says, they need to be well recognized and kind of established arbitral institutions. So. And what are the consequences? So if, take for example LSA. LSA was for a long time a very popular venue in which Russian disputes were referred to and they were considered. But now LSAs, until and unless LSA gets a permission from the Russian government, LSA, from the point of view of Russian law, will not be able to consider disputes relating to shares in Russian companies, for example. So there is a contract, sale purchase agreement with respect to shares in a Russian company. And from the point of view of Russian law, this will be an ad hoc arbitration, and it will not be enforceable in the Russian Federation. Also, if LCA administers arbitration proceedings taking place in the Russian Federation, this will also be considered as ad hoc arbitration, and any appointments, any steps taken by LCA will be considered to be illegal as a matter of Russian law. Well, you may wonder how this came to this situation in Russia, but the situation is there are several factors which affected this. One of the factors is that for a long time arbitration was widely used for illegal purposes, basically. For example, in bankruptcy proceedings, there was a practice when they were backdated awards, which allowed owners of a company to inflate claims against its own company and to control bankruptcy proceedings. Many issues, you may say that these issues shall be dealt with as a matter of law enforcement. Investigations by the police, fraud cases. I fully agree with this, but obviously the scale was such that, and also the complexity of such cases, because it's not easy actually to investigate such cases. That the Russian government simply decided, well, we need to put an end to this. We need to have some kind of form of regulation of arbitration in the Russian Federation. And they came up with a draft law, and it only related to registration of arbitration institutions in Russia. But then, comments were provided to the government that, well, it can be easily avoided by setting up an arbitration center somewhere in a neighboring country, issuing a similar award, and bringing it to Russia and enforcing it in Russia. And a reaction to this was actually, well, that the government said, well, we need to do also something with respect to arbitration institutions outside of the Russian Federation in order to avoid, such misuse of arbitration. Currently there is a debate, not only in Russia, but also among leading international arbitration centers. Last month I chaired a session in Moscow in which representatives of 6 international arbitration institutions were present: ICC, Stockholm, Malaysia, Vienna, Singapore, Hong Kong. I would say that there were different views among them with respect to whether they will want to comply with these requirements of Russian law. So some say that, well, it imposes administrative burden on us. It can raise questions about independence when Russia, for example, is a defendant in proceedings. ICC and Stockholm, they were, I would say, quite cautious about this. Singapore and Hong Kong, they said that they are still thinking and they will probably be applying for such a permission. And Vienna and Malaysia, they have already applied. They are in the process of getting this permission. So now we're in this kind of global world of international arbitration, where there is competition between arbitration institutions. It's and everyone wants to get more cases for them. It's quite difficult to deal with this situation.
Have sanctions had an effect on the geographical location of the institutes?
Yeah, that's right. That was kind of the second topic which I wanted very briefly to raise, because for a long time there was a strong reliance by Russian business on arbitration in the West. So it's London, Paris, Stockholm, the quite popular venues for disputes. And then, suddenly, with the sanctions, which were kind of unilaterally imposed by some countries, it was impossible for many Russian businesses to defend their rights. they had arbitration clauses in favor of LCA, for example, but then LCA would say, well, I cannot accept money from you because you are in the sanctions list. So what do they have to do? How will they protect their rights? And that was that was very irritating, and that was very seriously taken by the Russian business. And there was a strong, there is a strong inclination, and we see that there are lots of clauses now entered into in favor of Singapore and Hong Kong. And they are actively marketing themselves in Russia as a venue jurisdiction which is free of sanctions, which can provide same level of service, even better, English law, experienced arbitrators, and they are becoming more and more popular.
And they, of course, will be registering in Russia.
They already for 1 year they are saying that they are thinking about this, but no one said that. Well, they are kind of against it. I think ultimately they will apply for authorization by the government. And then very briefly, kind of the third issue which affects arbitration in Russia is I've attended an event in India at the end of last year, and the purpose of the event was actually within the BRICS countries. There is a discussion now that there shall be some either a separate arbitration institution for disputes between BRICS companies from BRICS countries, or arbitration centers in the BRICS countries shall be used for disputes, for such disputes. And why does this question come up? Because BRICS are kind of developing countries, and it happens for some reason that disputes between companies from developing countries are referred to arbitration centers in the developed countries. From the point of view of many lawyers, it doesn't make any sense because, for cultural reasons and many other reasons, it is considered that the option which disputes will be considered by the BRICS countries themselves is the preferred one. So this, I would say, is the kind of third issue which affects development of Russia-related disputes.
Thank you, Timur. That's fascinating. And so, actually, it doesn't sound quite as collegiate with a focus on BRICS dominance of internal arbitrations. But turning away from Russia for the moment, Anthony, Russia seems to have adopted a more restrictive approach, perhaps to clean up its own arbitration industry to a certain extent, but also from a competitive sort of viewpoint as well. What can the Caribbean learn from the stance Russia has taken? Perhaps a more liberal approach?
Well, first of all, good morning to fellow panelists and, of course, a very distinguished audience. And, of course, I'm very delighted to be here and to share a few thoughts with you on this topic. And, of course, I'm very grateful to the very kind invitation extended to me by the BVI-IAC to do so. So just as a direct response to Andrew's question, I think one of the issues that needs to be borne in mind is that the Caribbean is not actually a homogeneous region. Of course, as you may have heard from others as well earlier today, that we share both a common law and a civil law tradition, and the civil law is particularly appropriate in relation to Guyana, Suriname, Haiti, and St. Lucia. And of course the rest of the Anglo-Caribbean employs the common law. So to a great extent, of course, we are seeing a number of variations. Also political systems vary across the region as well, and this may or may not determine whether a restrictive approach or a liberal approach can be practiced in relation to arbitration. It perhaps goes without too much emphasis in saying that democracies on the whole tend to be more liberal in orientation, where centrally controlled states such as Russia and perhaps China would naturally in some ways be more restrictive. And one of the things I also want to look at would be the role of Cuba in relation to its role in the region in general. So if I start off initially with Jamaica, and we've heard a little bit about Jamaica earlier from John Bassey, one of the interesting things is that the initiative to modernize the approach to arbitration there came not from the government or indeed from the private sector, but from the University of the West Indies, and which in collaboration with the Kuala Lumpur International Arbitration Center established something called the MONA International Center for Arbitration, which is actually based on the campus of the University of the West Indies. And it goes by the acronym MICAM, and MICAM begins with the agreement of two more parties for the reference to arbitral proceedings under its own rules. And it also offers a fairly comprehensive procedural process whereby parties can agree to the conduct of arbitral proceedings arising out of their commercial relationship. The government itself, of course, has also gone a step further, but the MICAM rules, I think, are an important initiative taken by the university in terms of furthering the cause of arbitration in the region. And it may well be that this is going to be a useful model for not only other branches of the University of the West Indies, but tying in the role of educational institutions with promoting arbitration in the region generally, and hopefully in other places throughout the world as well. The other point that needs to be made is that the state of Jamaica itself, of course, is shortly to usher in the regional into its jurisdiction, the arbitral model law, with appropriate modifications. And of course, these include some very, very useful features, particularly facilitating foreign arbitrators and having the ability to conduct arbitrations there, having rights of audience before domestic courts, which of course may be relevant from time to time in the event of queries arising during the course of an arbitration. And of course, in conjunction with the Chartered Institute conducting intensive training of local and regional arbitrators. And what I think is going to take place later this year in August, I'm told, by the former chair of the Chartered Institute Caribbean branch, is sensitization of the judiciary in relation to arbitration, something that I think we need to bear in mind. Again, it's a very critical initiative that is being taken there. If I turn briefly to Trinidad and Tobago, and I mention this because it's the second largest country in CARICOM, and perhaps in some ways the wealthiest. It's an oil and gas-based economy, perhaps not good news right now given the declining oil prices, but nevertheless it actually has given rise to some very useful arbitrations over the years, and it's principally been promoted by something called the Dispute Resolution Center. The DRC, of course, serves to administer both mediation and arbitration services, including rostering mediators and arbitrators, and significantly there has not been a lot of state support for arbitration. In fact, the laws there are woefully out of date, going back to 1939, so this is something that I think as a jurisdiction this has to be certainly looked at quite seriously. But I think the DRC, interestingly enough, started life as far back as 1996, and of course in similar ways to the BVI-IAC has its own board of directors and operates in a completely autonomous way as a neutral organization, and I think that in itself has been quite useful in terms of attracting arbitrations there. So it's had also significantly in terms of its international connections, long-standing representation on the International Court of Arbitration in Paris. In fact, one of the former retired judges there, Justice Alcalde Warner, served as the DRC's representative on the ICC's International Court of Arbitration in Paris for a number of years. The BVI we've heard a lot about during the course of this week, not only the keynote presentations by Sir Dennis and of course I think John Beecham yesterday, but also this morning. But it's interesting that as a more recent entrant into the global arena, started life in 2014. As you know, it significantly benefits from adopting the arbitral model law and of course the New York Convention 2014. And of course, it does enjoy tremendous support from the government in contrast to Trinidad and Tobago, whilst of course having necessary safeguards to ensure that it operates in a neutral way. So that in many ways, I think it's a tribute to those who created this institution, the vision that they've had as to positioning BVI into the global arena. Turning briefly to Cuba, because perhaps we haven't heard a lot about this, but it has a long history in the region. And, you know, again, this goes back to 2007, when a particular law was passed by the Cuban government, which set up something called the Cuban Court of International Trade Arbitration. But that in itself links to an earlier court of arbitration of foreign trade, which was created since 1963. So, you know, in some ways, the Caribbean is not such a new entrant into this arena. It actually, through Cuba and perhaps one or two of the other jurisdictions, has been around for some time, some 53 years in the field of arbitration, interestingly enough. And it too has an executive board, which serves for a relatively short term. It also seeks to resolve contractual and extra-contractual matters, whether be it that concerns litigation or arbitration, and of course it also offers conciliation and mediation services. But significantly, the procedure adopted in arbitral proceedings seems to be quite standard. There's no indication, at least from the information I have, that there's been any interference by the government, just because it happens to be a socialist state. And I think that is good news in many ways for how one can see the region positioning itself in general to offer arbitral services. And then finally, of course, we've also heard earlier today about Singapore. And the statistic was given, if you look at the fifth bullet point, of the number of cases filed in Singapore, 343 from 56 jurisdictions, an exponential increase of 27% from 2015. And the board of directors come from a number of different jurisdictions, Hong Kong, India, Singapore, and China, emphasizing the global nature of arbitration in many of these new centers. So I think, Andrew, in response to your question, it does seem to me that it's good news for the Caribbean. There's a lot of work to be done, but I also think that we are moving in the right direction.
Perfect. Thanks, Anthony. Taking George's pessimistic viewpoint for a change, how realistic is it that these regional centres can all survive in the face of established centres such as New York, London, Stockholm? And what do they need to really focus on to make sure that they get a seat at the table? I'm going to throw that at Angeline.
Give me the pessimistic point of view. Well, I think, I mean, obviously, when I was speaking earlier, I was talking slightly in terms of generalisations, and I think probably each regional centre will stand and fall on its particular characteristics, not so much the in terms of the arbitration services it provides in the legal framework, because, as I said earlier, I think that's becoming standardised. But if, for example, you were to take Mauritius as a jurisdiction which is essentially set up to try and capture the India and the African market, well, I would think that actually it may have some serious challenges in front of it, because India has now its own institution. It, outside India, had typically referred things to Singapore. Africa, Mauritius is not particularly easy to get to from Africa, and I think there will become a time where Africa will look to set up its own institution, because many of its disputes still go outside of the region. But I think the lessons that you could learn from Mauritius wouldn't necessarily apply to this particular region, because there are different market forces at play. So I think the truth is not all of them will survive. But some stand a very credible chance of surviving, and I think one way in which they can survive is by not having too much direct competition in their marketplaces. So, for example, if you have too many people trying to do the same thing in a closed space, that's not going to be helpful. But also just focusing really on the jurisdictions which are most relevant to you. So one of the things that John Beachy said last night, which really struck a chord with me, is if you are able to establish direct routes into Panama and Miami, that's going to be tremendously important, because many disputes in Latin America are still being sent outside of that region to be resolved, many arbitration disputes. And I don't see, there's a lot of work being done in Miami, but it's still not as established as other places like New York and Washington and so forth. So I think it's about understanding your market and being, quite ruthless and making sure you've got the best infrastructure to attract it.
I agree, just making sure it's just relevant. There is actually a market there. It's like the BVI, if I can be more positive now for a change, it seems there's a wonderful opportunity here for the BVI, both in terms of the Caribbean, we've heard about Cuba, but it seems to be there are opportunities for the BVI there, opportunities in South America, and of course tying in with the court infrastructure here as well. So you can see, just looking at the BVI, for example, about the upside, the more positive story, and just tying it into market.
And I think it goes back to a point Angeline raised about Indian arbitrations, that you have a 12-month stop dead date, otherwise you get put back into the court system. But of course, I think I'd rather be put back into the BVI court system, where you're going to, you'll get a decision quickly, than being put back into the Indian court system. No disrespect to any Indian delegates here, of course, but you need to know that court supervision is there in a responsive and efficient manner.
Or the British or the English court system, where you now about 2 years get a decision from the Court of Appeal, so you're far better off here.
Yeah, backward jurisdiction.
Yeah, exactly.
And George, what threats are there for international arbitration? We've heard of some of the issues that Timur and Russia face, and in fact, we have one of our judges here who had to deal with a fraudulent arbitration award, which after some digging we found out the arbitrator was actually incarcerated in a Siberian prison at the time the tribunal took place. But he did say that he wouldn't take oral evidence as part of the award, which I thought was very clever of him.
It also sounds like the ideal place to sit down and draft an award. You've got no excuse for any delay whatsoever. The ICC ring you, say it's fine, I'm stuck in prison. It's one interesting point, and this was touched on again by John Beechey last night, in terms of the role that governmental bodies might start to play in appointing arbitrators in the context of trade disputes. And one concern I have, I think one threat to arbitration, is the recent momentum behind the suggestion that the party appointment process should be revisited in the context of commercial disputes as well. The party appointment process not only ties in with the tenets of party autonomy, but it also lends arbitration that wonderful sense of independence. And as soon as we imbue institutions with too much control, one can see that arbitration could very well lose that sense of transparency, even if in the short term that might look like a nice way to deal with concerns about corruption or diversity. The best way to ensure that arbitration flourishes, it seems to me, is to allow the parties to have that autonomy and not run scared from it. So I think that is currently a threat, I think.
Thank you. And Timur, I think there's talk of a central registry for awards in Russia, probably as an antidote to what we've discussed and seen in the past. Do you think that's a global issue, or just one in particular for your region?
Well, it's difficult to say. Well, certainly there was such a problem in Russia, and when Russia started to, wanted to regulate this, it came across a situation that you cannot regulate international arbitration. It's very difficult to regulate international arbitration on a national level. So it has either to be international regulation of international arbitration, or such kind of clumsy things as the new Russian arbitration. I think generally I think it's only kind of matter of time when people start doing some shady things with arbitral awards in other parts of the world. So it's always the case that it starts somewhere and then it becomes more and more popular. So I think ultimately we will face a situation when international arbitration community and kind of international community in general will face this problem, and arbitral institutions will have to be regulated somehow on international level.
What do you think, Angeline? Is that time coming?
What I was going to say is that I think actually the threat to international arbitration comes from where we're not quite looking just yet. Just to go to give a sort of broader speech, one of the things that everyone in the arbitration community was very focused upon last year was a speech by Lord Thomas, our Chief Justice in England, where he spoke about awards, the stunting of the development of the common law, because arbitral awards are confidential and therefore we can't see what's being said, we can't then develop precedent and so forth. But I think that was really not, that was the speech that we shouldn't have been looking at. The speech we should have all been looking at was a speech that he gave in Singapore at the end of last year, towards the end of last year, where he was talking about international cooperation between the international courts, so England, Singapore, Dubai is where most of the work has been done. I think there was an announcement last month that they've set up some sort of body or commission that's going to look at international cooperation. What's particularly interesting about his speech in Singapore is that he talks about we could have rules which we apply between all three of the courts. They could be rules which take into account civil and common law procedure. They could be rules which are not terribly prescriptive. It all starts to sound a little bit like arbitration to me. And of course that is some way off, but if you also take that combined with the Hague Convention, which sets up a sort of New York Convention type enforcement regime for agreements with exclusive jurisdiction clauses in. Say you were to then, and if you had enough of a sign up to that, bearing in mind New York Convention took about 50 years, so if, a few years hence, that could really be a credible alternative to arbitration using the court through exclusive jurisdiction clauses. So I think the pressure will come on international arbitration to compete in due course, and we will have to address not so much some of the regional issues, but some of the credibility issues which John spoke about last night.
Yes, thanks, Angeline. It was particularly resonant for offshore practitioners hearing John last night and understanding the backlash that some of the BIT arbitrations have brought the industry. And it was, there were huge parallels to be drawn from some of the criticisms offshore has faced over the last few years, of course. And I was slightly nervous about whether, as an offshore arbitration jurisdiction, we should also be dealing with BIT disputes as well, and whether it would be a perfect double whammy for us in the Guardian if we weren't careful. Next question for Anthony, and we're running out of time. I've just been given the 5-minute signal. Right. What can the BVI really do? And this is a question that we've asked ourselves a few times. Yeah. What can the BVI really do to differentiate itself from the Singapores and the Viennas and the Hong Kongs?
Well, I'm not sure if it really wants to do that. I mean, I think obviously all Caribbean jurisdictions want to continue to attract foreign direct investment. That's in a sense one of the driving forces behind establishing centres, modernising laws and legislation, and even some of the initiatives taken at the university level and at the law school as well. So I think we need to cite it within that context. But I also think that we've got to be careful not to have a proliferation of IACs within the region and so on. I mean, we obviously want to ensure that investors are going to feel comfortable in knowing that their disputes are going to be dealt with impartially and objectively, fairly and expeditiously. But having said that, I also think that one of the observations, and I think a key observation made by Sir Dennis Byron when he was here on Tuesday in terms of giving the feature address was to point to the role of the Caribbean Court of Justice, which of course potentially can offer arbitral services as well. It's set up in the revised Treaty of Chaguaramas. But specifically in relation to BVI, certainly I think it needs to work in conjunction with other Caribbean jurisdictions. And I think it's also important to recognize that the dynamics are changing, and we've got a host of lawyers from a number of different jurisdictions working here. I mean, it's a sort of global village really in a sense, and I think that's very, very significant for the BVI in terms of what services it can offer for the future, because a lot of the lawyers come from the metropolitan countries that have been the main centers of arbitration throughout the world, and of course we're talking about London and New York and Paris and a number of these other countries, but they're now working here. And of course, not to say that they have severed their linkages with their organizations or their countries, but the fact that they're here, they're looking to promote BVI, and I think that speaks to the fact that BVI is going to hopefully be set to take off and to really offer extensive services in this area, hopefully in the years to come. So what I'm suggesting is that we don't necessarily need to just have a standardization of practice and procedure. We're seeing that, as Angeline has said. What we need to have is a change of mindset, a change of culture, and knowing that Caribbean leaders can work together with others to develop that strong reputation for excellence in arbitral work, in this centre, which can compare favourably with any centre throughout the world.
What a great answer. Thank you, Anthony.
Thank you.
I hope someone's writing that down.